Are you responsible for your spouse's student loans? Let's compare when student loans are taken out prior to marriage to when they are taken out during the marriage. So if a spouse takes out student loans prior to marriage, then that student loan debt is going to be their separate property to which they are responsible for solely paying. If your spouse takes out the student loan during the marriage, then that still is likely going to be their separate property debt. And what that means is if the community actually pays down the student loan, so if you use your income during the marriage to pay down the student loan, then the community is actually going to be entitled to a reimbursement for that pay down. However, if they take out the loans though, and you've been married for 10 years or greater, there's a presumption that the community has actually benefited from this person's loans or this person's degree. And in that case, you're likely not going to actually get a reimbursement. Like with most things, there's an exception, and that presumption can actually be rebutted if you can show that the community did not actually benefit from this student loan. And so, for example, if your spouse went to school to become a vet, but then they actually never decided to be a practicing vet, then obviously the community has not benefited from that degree and or that student loan debt. And now that example may be extreme, but if you find yourself in a situation where there is substantial student loan debt in your case and you're going through a divorce, you definitely are going to want to contact a family law attorney to analyze that issue further. Follow for more, and if you have any questions, contact Bremer White for a consultation.